We believe it does not benefit the pretrial chamber or the precarious state of health of our client, Mr. Ieng Sary, who have to listen to submissions about issues on which we have already filed extensive written pleadings. We also submit that this should be the approach of your honors towards both the office of the co-prosecutors and the lawyers for the civil parties in actively limiting them to making submissions on the issues we have raised in our appeal. Or on issues which they have raised in their responses to our appeal and to which we must reply. Summary of argument. There are two areas I would like to focus on today, which will be set out as the following as per our appeal. 1. Continued imprisonment of Mr. Ieng Sary is not necessary because he does not fulfill any of the criteria set out in Rule 63(3)(b). 2. Alternatively, if some form of detention is required due to the risk posed to the Rule 63(3) objectives by Mr. Ieng Sary, house arrest should be ordered as A. Imprisonment is not the only form of detention permitted by the rules. B. There are reasonable conditions of house arrest available to the office of the co-investigating judges. And C. If these reasonable conditions of house arrest would protect the objectives set out in Rule 63(3)(b), imprisonment may not be ordered as it is no longer necessary. The criteria set out in Rule 63(3)(b) are not fulfilled. Turning to the application of provisional detention, Mr. Ieng Sary is detained by the OCIJ under 3 of the 5 prongs of Rule 63(3)(b), namely that provisional detention is necessary to 1. Ensure the presence of the charged person during the proceedings. 2. Protect the security of the charged person. Or 3. Preserve public order. The pre-trial chamber has previously held that in assessing whether there is specific evidence to support an actual risk to public order, a measure of prediction is required. That is the pre-trial chamber's decision on appeal against the provisional detention order of Ieng Sary, dated 17 October 2008, paragraph 112. In fact, this measure of prediction applies to assessing all of the objectives under Rule 63. This is because when a charged person is provisionally detained under this rule, he is detained not because of what he or she has done, but what the OCIJ or the pre-trial chamber predicts that he might do or might not do, or more importantly, what may be done to him in the future. In other words, the pre-trial chamber or the OCIJ must predict whether Mr. Ieng Sary, if released, will try and run away and avoid trial, or whether his release would cause a threat to public order, or indeed a threat to his own safety. In making this prediction regarding Mr. Ieng Sary's future conduct under Rule 63(3)(b), the pre-trial chamber must be careful not to select as a matter of course the least favorable outcome for the charged person. This appears to have been the course taken in the past. For example, while there may be evidence that would support a prediction that Mr. Ieng Sary may attempt to flee, if there is evidence or factors which counter this hypothesis, in application of the principle of in dubio pro reo, the benefit must be given to the charged person and he should not be detained under this ground. To demonstrate how drawing inferences in favor of the charged person operates in practice, the defense refers to the recent International Criminal Court decision on the prosecutor's application for an arrest warrant to be issued against Hassan Ahmad al-Bashir, dated 4 March 2009, paragraphs 159 to 161. In this decision, the pre-trial chamber rejected the prosecutor's application for an arrest warrant for the crime of genocide. This was because, although it was reasonable to conclude that Bashir had committed genocide based on the materials provided by the prosecution to the pre-trial chamber, there were also other reasonable conclusions that could be drawn from the same materials, namely, that he had not committed genocide. In these circumstances, in application of the general principle of in dubio pro reo, doubt is resolved in favor of the accused, and no arrest warrant for this crime was issued. It is also noticeable that this principle applies not simply when the prosecutor is required to prove guilt beyond reasonable doubt at trial, but also when the standard is much less. In the Bashir case, it applied when the prosecution had to simply prove that there were reasonable grounds to believe he had committed this crime under Article 58 of the ICC statute. It is unclear what standard of proof applies when the pre-trial assesses whether the rule 63(3)(b) criteria have been fulfilled. But even if the pre-trial chamber need only be convinced of a reasonable likelihood a condition will be fulfilled, any doubt as to whether there is correct or not, it must be resolved in favor of Mr. Ieng Sary. In truth, there is simply insufficient evidence that provisionally releasing Ieng Sary as an individual would pose an actual risk to any of these objectives. In fact, the OCIJ's conclusions on these matters are based on nothing more than the malevolent behavior of other people, tenuous interpretations of irrelevant evidence, and reliance upon the least favorable interpretation of hypothetical considerations as explained above. In relation to the threat to public order and the threat to Mr. Ieng Sary's safety, there are two elements in Rule 63(3)(b) that do not require any blameworthy conduct by Ieng Sary to justify his continued provisional detention. In truth, relying on these criteria borders on violating the presumption of innocence. They are relied upon to justify Mr. Ieng Sary's continued detention when he has not caused these factors and he is powerless to do anything to prevent their occurrence. Therefore, these grounds for detention must be used with considerable caution. Furthermore, in their response to the defense's appeal on the predicted threat to public order caused by Mr. Ieng Sary's release, the civil parties have gone one step further than simply relying on some abstract risks to public order caused by anti-Thai riots 6 years ago. They have relied upon the disturbance that one of the civil parties created after the Khieu Samphan provisional detention hearing on the 3rd December 2009 in order to claim that Mr. Ieng Sary's release would cause a threat to public order. This argument is akin to the civil parties threatening to kidnap Ieng Sary and then claiming that as his presence at trial could not be ensured when he should be detained, then he should be detained. Therefore, the civil parties must not be allowed to profit from their implied threats against Mr. Ieng Sary with regards to the alleged threat to the safety of Mr. Ieng Sary. Based on his alleged nexus to Dutch, such a conclusion again ignores any action on behalf of Mr. Ieng Sary and instead relies upon a very simplistic view of the relationship between the charged persons. The OCIJ does not cite to any particular evidence or Dutch implicating Mr. Ieng Sary from any one of the many statements given by Dutch to the OCIJ. Instead, it simply considered that once it becomes public that there is an alleged nexus between the purported crimes of Dutch and the allegations against Ieng Sary, those who feel they have reason to threaten Dutch security may feel those same reasons now apply to Ieng Sary and might therefore feel inclined to threaten him too. That's OCIJ order, paragraph 27. Although the OCIJ repeated the defense's argument that no account is taken of the differences between Mr. Ieng Sary and Dutch, it failed to answer this argument. Furthermore, these statements by Dutch have been confidential up until now due to the principle of the confidentiality of the substance of the investigation, and so the public would not be aware of exactly what Dutch relationship, if any, was to our client, Mr. Ieng Sary. Regrettably, the OCIJ seeks to rely upon this misunderstanding by the general public of Dutch relationship with Mr. Ieng Sary rather than seeking to correct it. Essentially, Mr. Ieng Sary is being punished by being provisionally detained under this ground because of the supposed belief by the general public of his guilt for the crimes for which he is being investigated. He is therefore being detained due to the court of public opinion rather than the rule of law. Your Honors, the final ground of Rule 63(3)(b), under which Mr. Ieng Sary is detained, is that his detention is required to ensure his presence at trial. As repeatedly stated by the defense, this finding by the OCIJ completely overlooks the fact that Mrs. Ieng Thirit, Mr. Ieng Sary's wife of 50 years, is also detained at the same ECCC detention unit. If Mr. Ieng Sary fled, then he would not be able to see his wife. This factor clearly has never been raised before other international criminal tribunals, as never before have a husband and wife been detained together? Nor has it been sufficiently considered by the OCIJ. Furthermore, as will be extensively set out by my colleague Michael Canavas, Mr. Ieng Sary is an old and very sick man who needs constant access to medical attention. He is not, as seems to be the impressions created by other parties to this appeal, able to run over the border into Thailand. Detention at the ECCC detention unit is not necessary, as house arrest equally ensures Mr. Ieng Sary's attendance at trial, ensures his safety, and protects public order. Even if the honors consider that some form of detention is necessary to protect the objectives set out in Rule 63.3, as repeatedly highlighted by the defense, house arrest would adequately do so. This is permitted under the rules, and the Cambodian Criminal Procedure Code it also would be cheaper for the court. It would constitute a lesser infringement of Mr. Ieng Sary's right to liberty and security of the person of an individual who has not yet even been convicted of a crime. And would actually increase the chances of Mr. Ieng Sary being able to be tried before this court. In assessing whether detention is required, the OCIJ is under an obligation to order the least restrictive means necessary to achieve the objectives set out in Rule 63.3. Therefore, house arrest is that least restrictive means. Your Honors, the OCIJ has completely and unequivocally failed to explain why house arrest or hospitalization would not achieve the objectives of Rule 63.3b. Nor have they disputed that house arrest or hospitalization interferes less with the charged person's right to liberty or health as protected by the Cambodian Constitution and international covenants to which Cambodia is a party. Instead, they have simply stated that there are no reasonable conditions of house arrest which could be imposed which would guarantee the objectives of Rule 63.3b from point 3 to 5 to the same extent as provisional detention. That is the extension order, paragraph 36. Your Honors, in order to explain exactly how the OCIJ has failed to properly apply Rule 63.3b and to further articulate the failures of due diligence in the OCIJ's investigation, I will now hand over to my co-lawyer for the rest of the defense's oral submissions. Thank you, Your Honors. The President. The chamber will take a 15 minutes break now. The graphic, all rise.